They rejected me because my LSAT score and GPA weren't high enough? How is that possible? I know people who had a lower score than me and they were admitted. I know the real reason is because I'm not part of a minority. That's not fair. I won't accept this. I have an equal right to be accepted as anyone else does. I'm going to fight for this.
All rise. Good afternoon. We are here today to discuss the legitimacy of University of Michigan's admission process. Barbara Grutter is the plaintiff and Bollinger is the defendant. The plaintiff complains that she was rejected admission to the university because she does not belong to a minority group. Please be seated. What does the plaintiff have to say about her case?
Judge, I believe that the application process used by University of Michigan Law School is unconstitutional. I was rejected by the university in spite of my GPA of 3.8 and LSAT score of 161 due to my race. I was rejected because I do not belong to a minority group. I have previously been to a lower court which ruled the university's admission process was unconstitutional. However, the case was further taken to the Sixth Circuit Court of Appeals, which reversed the previous ruling. The appeals court ruled that considering race is all right due to increase student diversity. I am here today to ask for the Supreme Court's aid in executing my right to equality given to me by the 14th Amendment. Moreover, the university's policy also violates Title VI of the Civil Rights Act of 1964. Do I not deserve the right to be admitted?
What does the defendant have to say about his case?
Judge, I agree that the university does take race into account while admitting students. However, we do this to increase student diversity in our university. We aim to encourage African Americans and Hispanic populations to apply to our university. We wish to ensure that these minority students do not feel isolated, or, like their spokespersons for their race, to provide adequate opportunities for the type of interactions upon which educational benefits of diversity depend, and to challenge all students to think critically and to re-examine stereotypes.
The constitutional question before us today is, does the University of Michigan's law school's use of racial preferences in student admissions violate the Equal Protection Clause of 14th Amendment or Title VI of Civil Rights Act of 1964? Should affirmative action be upheld, or is it unconstitutional?
Bang bang.
I, Justice Sandra O'Connor, am here to announce a ruling of the Supreme Court. The ruling is in the favor of the defendant by a vote of 5 to 4. The court holds that the Equal Protection Clause does not prohibit the law school's narrowly tailored use of race in admissions decision to further a compelling interest in obtaining the educational benefits that flow from a diverse student body. Because the law school conducts highly individualized review of each applicant, no acceptance or rejection is based automatically on a variable such as race, and that process ensures that all factors that may contribute to diversity are meaningfully considered alongside race. The law school's race-conscious admission program does not unduly harm non-minority applicants. However, affirmation action policy is not a permanent act. We should all work toward a colorblind admission process in the next 10 to 20 years so that no encouragement should be required for any minority group. The dissenting opinion was that the law school's admission policy was an attempt to achieve an unconstitutional type of racial balancing. The diversity argument was not compelling enough to support their actions. The university's narrowly tailored use of race was to further their personal interests. I'm really sorry for your loss.